rise. The Court of Appeals, Division 1 is now in session.
Please be seated. We're here in our case Monday CV19-0197 Bernardo versus Windsor. Each side will have 20 minutes to present argument. Appellant, you may reserve any amount of time for rebuttal that you want, but you're responsible for keeping track of the time yourself. We have a clock at the podium for that purpose. We are recording the argument, so please identify yourself and your client when you begin your argument. We've read the briefs, looked at the record, and conferenced the case, so we're familiar with the case. So when you begin your argument, just start off with what you would like for us to know. Counsel, you may begin. Surely. I did that once myself.
Good morning, Your Honors, and may it please the Court. My name is Rita Bustos, counsel on behalf of appellants, defendants, Windsor, Palm Valley, et al. I would like to reserve 5 minutes for rebuttal, please. Appellant asks this Court to reverse the decision below, denying its motion to compel arbitration for 4 reasons. First, appellants did not waive their contractual right to arbitration. Second, plaintiffs' claims constitute healthcare negligence and are thus medical malpractice as defined in the arbitration agreement.
Counsel, how is moving someone from the room to the dining room malpractice?
Absolutely, Your Honor. Your Honor, plaintiffs' claims are much more than just the simple act of pushing the elderly resident, Mrs. Bernardo, in the wheelchair. Either under the express language of the arbitration agreement or the definition of medical malpractice under Arizona law, plaintiffs' claims fall within the purview of the agreement.
Well,
Decedent?
I'm sorry to interrupt. You talked about the definition in the agreement and then the definition in the statute. Aren't we all bound by the definition that's in the agreement, which you're perfectly fine to agree to whatever you want to agree to, and what the statute says really doesn't matter at that point.
And Your Honor, again, if we're looking just at the contractual language in the arbitration agreement, then plaintiffs' claims do fall under that definition. Decedent was in Palm Valley to receive skilled nursing services and other healthcare-related services. Indeed, she was at the facility for almost 3 years before the wheelchair incident of receiving these healthcare-related services.
I guess let me first ask you, is it possible to have an ordinary tort within the 4 walls of a nursing home?
Absolutely, Your Honor. It would be possible to have a simple negligence premises liability action within the 4 walls of a nursing home.
Okay.
Can a resident have that?
A resident can have that tort. That's absolutely, but that's not what happened in this case and under the language of the contractual.
So explain, if you can, and I'll try to keep up, but the facts that distinguish this tort from an ordinary tort.
Absolutely, Your Honor. And to
I understand
answer,
it happened in a nursing home because we've already established that we can have an ordinary tort in a nursing home.
Yes, absolutely. Now, to answer that question, I'd like to go to the language of the admission agreement, some of the language in the admissions agreement, and then we'll go over the facts. In the admissions agreement, paragraph 1, it says you're authorized to administer and perform all services and treatments as prescribed by the resident's Arizona licensed physician. In paragraph 4, it says, I authorize you to provide resident with all things deemed necessary and proper for the health and safety of the resident, and if applicable, agree to pay for those services. Decedent in this case was in Palm Valley to receive skilled nursing services and other healthcare related services, including those under the admissions agreement. Plaintiffs do not dispute and indeed claim in their complaint that decedent was in a compromised physical and mental state as she suffered from dementia and other physical ailments.
So is that what makes it a medical malpractice?
Absolutely, and that's
that she was ill.
Yes, that she's in a compromised physical and mental state. She required supervision, and this comes directly from plaintiff's complaint. Supervision, close monitoring, and medical attention to ensure her health and safety and well-being.
What if this happened at a supermarket?
Your Honor,
Same fact.
Same facts if it wasn't a certified nursing
Let's
assistant.
say it was a certified nursing.
If
just taking their patient on a to the supermarket to get something that they've asked for.
If it was a certified nursing assistant pushing the person in a wheelchair because for their health and safety, which was necessary.
On aisle 3, they wanted soup. So
then
we go there, same thing happens, that's medical malpractice.
It would be medical malpractice as defined under the agreement, which has a definition.
So what is it, because dietary needs are certainly those, everything that you do, then you say constitutes a medical service. So how does a resident have normal tort?
Your Honor, I guess a normal tort perhaps would be constituted by another resident in the facility, a battery, for example. If there's a fight between residents, another resident hits another resident,
So
that
how
is
about
an
if
intentional
the CNA
tort.
actually punched her?
If this, then that would be a medical battery. That would not be a healthcare negligence or medical malpractice claim.
Because the punch was done by medical professional?
No, it would be a battery and not negligence. There is a difference between the two claims, an intentional tort or negligence.
When I go to church every Sunday, there's a van that comes from the local senior home, and there's a driver who assists someone out of the van so the person can go to church. If there's negligence there, does that count?
Your Honor, I'm not sure if the person who's driving the medical assistance van constitutes a licensed healthcare professional under the statute. I know that a CNA does, but we're also missing...
So does everything the CNA do then constitute providing medical services?
I mean, for the most part, and in this particular case, it does, because it was deemed necessary for Ms. Bernardo's health and safety under the admission agreement that she be ambulated around the facility in a wheelchair. That makes it a health care service. Now, if we look at the definition...
So what is the definition?
The definition... Correct. The definition of medical malpractice as set forth in the agreement is whether any medical service rendered under the contract were necessary or unauthorized or were improperly, negligent, or incompetently rendered. So, because it was a healthcare related service, a necessary for Ms. Bernardo's health and safety as she was a resident or a patient in the skilled nursing facility, that the certified nursing assistant had to ambulate her in the wheelchair around the facility, then that would constitute a healthcare service.
Isn't medical service also defined by statute?
A medical malpractice action is defined by statute.
I think, would you, we'll reach this in two phases. Number one, would you agree with me that the definition of medical malpractice in a statute has little to no value if the parties have defined the term medical malpractice and signed it in the four corners of their agreement.
That is correct, Your Honor. However, if there's any ambiguity as to what it meant, then we can look outside.
So then we have the term, you just read it, medical service. In the agreed upon definition of medical malpractice. Is that accurate? It's in the document, right?
Yes, absolutely.
Okay. And then medical service is defined under ARS, and it has a few elements. And one of them is that the service, I guess, has to be ordered, I don't have it in front of me, but by a physician or who else? Do you have that definition in front of you?
I do not have that definition in front of me. I do apologize.
Okay, so, well then let me, are you familiar with a definition? Is medical here it is, okay. Medical service, Arizona law defines it as services that pertain to medical care and that are performed at the direction of a physician on behalf of patients by physicians, dentists, nurses, but we're already past that. So that are performed at the direction of a physician. That is the express definition of medical services under ARS. What about pushing a wheelchair from the dining room after breakfast to the patient's room is at the direction of a physician?
Well, when the resident or the patient in this case is entered into the skilled nursing facility and it is documented that she cannot ambulate around the facility safely without being pushed in the wheelchair by the certified nursing assistant, then it does become a medical service as defined under the agreement. But
and
we're also...
Who's the physician and where is the direction? Is that in the evidence? So we have direction, which is a nominalization. It could be a verb or a noun, but theoretically there's a document or a communication in which a physician says X, Y, Z, and then we have a medical service. Who's the physician and what is the evidence of the direction that is in the record?
Your Honor, I'm sorry. I could not tell you who is the physician who may have ordered that Miss Bernardo be ambulated around the facility in the wheelchair. However, we also have secondary evidence in this case because plaintiff's claims are not just limited to the simple act of pushing Miss Bernardo in the wheelchair in this case. They have brought forth evidence, including expert medical testimony, that the negligent performance of pushing decedent in the wheelchair was connected to an alleged systemic healthcare facility issues, such as staff reductions, improper staff supervision and education, which allegedly constitute healthcare medical negligence. That broad claim does fall within the two-part test expressed by this court in the Jeter case.
Okay, so let's move on then to those other 2 points, which you have an argument that the evidence presented is, I think, systemic. And that transforms this into something other than an ordinary negligence claim. Would you concede, though, that you could have a systemic narrative and an ordinary tort that happens as part of that narrative? Well, why does systemic, the word systemic as an adjective, transform the ordinary nature of a tort into something extraordinary or medical?
Well, Your Honor, because what plaintiffs claim in this case is that the entire facility, Windsor Palm Valley, failed to properly train and supervise their staff regarding safety precautions, which allegedly caused or contributed to this wheelchair incident. They have made it a healthcare negligence matter. They're challenging Palm Valley's decisions affecting the treatment of its patients specific to wheelchair safety and precautions. Their case, the case that they have brought forth and which has been discovered so far, is a broad medical negligence case and not the narrow, simple premises liability case that the trial court sua sponte, decided their case was.
Okay, but would you concede that the word systemic, or if you have lots and sort of pervasive negligence, it can still be an ordinary tort? That's consistent with that theory.
Yes,
All
Your
right,
Honor.
so let's move to your expert witness, right? So your argument is, don't look at what we're saying, look at what they're saying. They disclosed an expert, meaning they felt that there was a need to establish a medical standard of care.
Correct.
So let me ask you, let's say we have a slip and fall in a grocery store, and the plaintiff identifies a nursing expert to establish a medical standard of care. But it's not required. I mean, in fact, we have a statute in Arizona that says if you have a professional negligence and certainly medical malpractice, there's no question. But it wouldn't be required in this instance of a grocery slip and fall. Does that become, based on the gratuitous identification of an expert that isn't required, a medical malpractice case?
No, Your Honor, it wouldn't, but that's not the case here. They
Well, can I
required,
Finish your answer.
of course, they required a medical expert because this is a healthcare negligence medical malpractice claim.
Let me ask you, because I want to focus. We're in a grocery store. We talked about slip and fall. But it's because, grocery store has done one of their holiday decorations, and they've run a cord across the floor. And my person goes in, I walk in, and I get my foot tangled up in the cord and fall. And let's say there's a CNA walking along with me because I'm coming from the nursing home. Now my foot's gotten tangled in the electrical cord, which is, as I understand it, what happened here. Is that a medical malpractice?
No, Your Honor.
So
And
now
it's,
tell me why, in this case, a patient getting her foot tangled in a medical cord that this nursing home has placed there has translated into a medical malpractice just because a CNA was involved.
And to phrase it just a little differently, in both instances, I guess the idea that the CNA should have been alert that, oh, there's a cord there. That would be the case in the nursing home or in the grocery store.
well, Your Honor, what makes this case different is that it was in the skilled nursing facility, number one. The CNA was performing a necessary healthcare-related function for Mrs. Bernardo as defined under the agreement. That's number two. And the agreement specifically says that any medical malpractice is defined as any medical service rendered under the contract if they were improperly or negligently or incompetently performed. That is what plaintiffs are arguing here. Plus, you have to look at the totality of the circumstances and their entire claim in this case. They are not making a simple premises liability negligence case. They are putting forth and discovering a healthcare negligence matter with requesting a plethora of documentation from...
Is it healthcare negligence, or is it just, and I'm asking you this, is there some claim called healthcare negligence, and what are the factors, or is it the nursing home had inadequate staffing and did other things that it should have done better? And how is that different than any other kind of claim where the grocery store, you should have had somebody checking the floor, you should have had somebody doing this, and they get the records and show that they cut their staff by 50%. How is it different?
Because it involves the exercise of professional judgment by a licensed healthcare provider, which in this case is Windsor, Palm Valley, and also the certified nursing assistant. I would like to reserve...
I've got to say, so I guess I'm kind of back to where the court is somehow also a decision that's a medical decision. So I come back to, how does anything ever constitute regular negligence? When you mop the floors, what signs you put up, you could make the argument, well, that's a medical decision.
I respectfully disagree, Your Honor, because we're talking about a healthcare service that is ambulating a frail, elderly lady with dementia who required that service for her to move about the facility. So, for example, if you had a patient at the skilled nursing facility that was there for rehabilitation after a surgery, maybe they're a younger person, they can ambulate around, they have their crutches, they're moving around the facility, that's perfectly fine for them. They don't need the assistance of a CNA wheeling them in a wheelchair, and there's water on the floor, and they slip and fall, then no, that would not be a healthcare negligence case that in that specific matter. Now, of course, if plaintiffs in that case tried to balloon it into that, which plaintiffs have done herein, then maybe it's a better argument, but that really would constitute a premises liability tort that would not perhaps be medical malpractice as defined under the agreement. I would like to reserve my time for rebuttal.
Of course.
Okay. Thank you very much.
Good morning. Good morning. Good morning. First of all, I'm Melanie Bossy, and I represent the Bernardo family in this matter. I'd like to start off with Judge Heggie got it right. Clearly, by the definition of medical services, the terms that the defendants put in their agreement is specific as to medical services. And pushing someone in a wheelchair where she gets her foot caught on a cord and get ejected from her wheelchair, breaking her neck and killing her, is not a medical service, first and foremost.
What is the dividing line between medical service and not medical service?
Well, the dividing line would depend. In this case, it's just custodial services versus medical services, and the CNA transporting the resident. You know, medical services would be different in providing medications and maybe doing treatments if it's a pressure sore case. You know, those would be more medical services.
So go ahead, finish your answer if you want. I have a follow-up on that, but go ahead.
No, so it really depends on the mechanism of the injury in each individual case. The mechanism of injury in this case, as we've been talking about, is her being pushed in a wheelchair, getting her foot caught, and getting ejected from a wheelchair. There's nothing about that service that is a medical service. It's a custodial service. That's why you've got the plethora of cases regarding fall cases in nursing homes that are custodial in nature and not medical malpractice in nature.
So that's a good segue. I didn't see it in either brief, but do you know where this language was pulled from this arbitration agreement? That is medical service. Do you have any sense? Okay, well, let me tell you. It's a California statute that says precisely in California, and this is a California company, you have to use particular language, okay? And you have a body of law in California interpreting that very language. Should we look to that law? Because if you look to that law, they interpret the term much more broadly than we do. Or do we look to your client's state of mind as they scribble their name on the document and what they reasonably believe it to mean?
Well, I believe we look towards the language in this four corners of the agreement and not to California law, because obviously the mechanism of injury happened in Arizona, the contract happened in Arizona, and they're bound by the definition that they placed in their arbitration agreement, and they specifically say medical services. They don't say this will cover any and all acts that take place in the nursing home, including custodial and medical. They could have defined it any which way that they chose to define it, but they chose to define medical services as medical services. And clearly, this is a custodial act, and it is not a medical service, hence the plethora of cases that I've cited in my brief.
And not to look at the California cases that actually interpret the very words at issue here?
You know, in California, obviously, different states have different definitions of what may be medical malpractice and what may be custodial. That's why you're going to have some difference in the cases. But when you take the overall look of fall cases, where a lot of them don't even use experts because it's custodial in nature, and just because I chose to be on the safe side and not have to appeal of not having an expert.
And that was going to be my next question.
See,
What is the significance should we ascribe to that? That you, a tip of the hat to a possible medical negligence loss or medical malpractice, disclosed a witness. Is that you capitulating on the character of the lawsuit?
No, Your Honor. Obviously, the mechanism of the injury is the same regardless. But as you can see from all the other case law, if you don't have a medical expert, you're opening yourself up for the potential of having it appealed, saying that you needed an expert. So obviously, I'm just being safe and, dotting my I's and crossing my T's so I don't get a directed verdict or I don't get a summary judgment. And the expert is more opining to the collateral direct liability of the company, obviously, of what they failed to do. They knew about how the room was set up. They knew that the roommate's bed was there with the cords. This specific CNA themselves told management that it was difficult to get Mrs. Bernardo to her bed on the other side of the room because of the way the room was set up. So this goes to the direct liability of the company. Separate and apart of what defines medical malpractice is the mechanism of injury in this case.
Counsel, I assume your argument would be the same if the CNA was assisting the patient with a shower and some accident happened in the shower. Given that, in preparation for surgery often, you have to wash the patient with a special soap. If the injury occurred in that circumstance, would that be a medical malpractice?
No, Your Honor. Again, going back, that would be a custodial service of giving someone a shower if it is in
even if
the
it's
nursing.
if it's a step before surgery.
Now, that may be a little different depending on.
A little, or I mean, just a shower alone, untethered from anything, or a shower preceding surgery.
Okay, it depends on really the facts before the surgery. If you're in the pre-op and you're wiping down and giving a bed bath, I don't think they'd have a stand-up shower in pre-op. But if you're giving a bed bath, and for instance, you might have rolled the person off of the gurney, I'm trying to add to the facts, then that may be a medical malpractice depending on who the professional is that did it. Was that in preparation for the surgery? But taking that example just a step farther, say surgery is at 2 o'clock, and in the morning at the hospital, you've got a custodial person bringing that person just to a shower to clean them for the day. That would be two different fact scenarios, and I believe that would be custodial versus medical malpractice. So I'm just kind of differentiating the facts a little bit, and really that's what it comes down to. It comes down to the mechanism of injury and the facts in this case.
What if she was wheeling her to surgery?
My position would be, depending on whom is wheeling the person to surgery, that still may be custodial in nature rather than medical malpractice. If you just have the orderly, say surgery's on floor 4, and she's down on floor 2, and just an orderly is bringing her from floor 2 to floor 4, and slips out of the wheelchair or gets caught on something, I think that still would be custodial because the mechanism of the injury. The destination really wouldn't matter there. But again,
So
then
you're asking us to accept that the destination or the, I guess, where they're coming from is irrelevant in this case. It didn't matter that this person was coming from a dining room and breakfast. You would be asking for the same argument if it was to or from surgery.
depending on the facts, yes.
Well, those are the facts.
Then
Same
I would
exact
agree
everything.
it would be custodial. The exact same thing happened in this case, going for an orderly going to surgery, it still would be custodial. Now, I think where the panel is going, say if a person's being transferred onto the surgical table and in that transfer gets injured, then again, that may be, depending on the facts and whom did the transferring, a medical malpractice action. Because that was, basically part of getting ready for the surgery. But just transporting from one floor to the other, it doesn't matter what the mortar you're in, whether it's a grocery store, whether it's a nursing home, or whether it's a hospital, that would be custodial in nature, and that's where, the case law, supports that.
And I assume it wouldn't matter who's doing the pushing. Perhaps the doctor is impatient to move the patient along, so the doctor actually pushes the patient and the injury happens. It doesn't matter. It means that it was the doctor who did it.
I don't think who's pushing would matter, because you take that to the next step. Say if it's a family member pushing their family member from floor 2 to floor 4. Again, that does not turn that mechanism of injury into a medical malpractice claim. So I really don't think the whom doing the pushing
But you would
make
concede,
a difference.
I mean, as we throw different facts at you, it becomes closer and more aligned to medical treatment. And if you're shuttling someone to a medical exam versus from the dining room, you're saying there's no difference between those two.
Again, it depends on the facts. Going on your scenario, say if my mom was pushing me or I was pushing my mom to a medical appointment or to receive medical services, it doesn't change that mechanism of injury into a medical malpractice case. So really, whom's doing the pushing really does not.
What if the surgeon is the one who said, go get the patient, and then you have the pushing?
I still think
That's a medical service under the terms of ARS. You have a physician who is instructing, and they're going to the surgery center or room.
I mean, I think that would be fact-specific under the circumstances of the case. Again, like if a physician instructed me to push my mom from one room down the hall to the surgery center, again, doesn't change that fact pattern into a medical malpractice case. So you've got to look at the mechanism of injury.
Well, no, we have the surgeon, we have the person who's providing the direction, and then we have the person who is acting. And there's 4 or 5 different names. And I agree, you're not one of them unless you're a nurse or a doctor.
Correct.
But that's not what I'm saying. I'm saying if you had a physician say, bring the patient to surgery, and we have here a CNA, I guess that's the acronym that's being used, push that patient to the surgery, in your mind, that's no different than what happened here.
It's not. I mean, really, it's just in transporting from one point A to point B. I think where it
you don't have to defend that, right? So you have a much easier case, isn't that what? Those aren't the facts you have, right?
Correct. That's not the facts I have. So obviously, Judge Heggie got it right, but what we can't leave to the wayside is the second element of authority in this case. And, I mean, bottom line is Judge Heggie said, this case is on all 4 corners with my Escareno case, that this person did not even have authority to bind his mom to an arbitration agreement. In my Escarino case, Dale the son, on 3 different occasions, had admitted his mom into a nursing home and also signed health-related documents. And the Escarino court says, just as people get older and aging, and we as children aid our parents by admitting them into nursing homes to get medical care and paying their bills, does not turn into the Resga situation with husband and wife and a long-standing history of signing with the principal's consent. So there's no evidence in this record whatsoever that the principal, being Mrs. Bernardo, gave authority to her son to bind her under the APSA count to binding arbitration. So we've got multiple reasons why Judge Heggie's ruling at the trial level can be upheld in this matter.
Counsel, if the patient is too, let's take this situation where the CNA is assisting the patient to the dining room or from the dining room, and the patient is walking, but the patient is too weak to walk. It would have been more appropriate for them to be pushed in a wheelchair. Is that medical negligence where the CNA makes the wrong choice of transportation?
No, again, Judge, it's custodial in nature. I mean, that is custodial services. And when you're providing custodial services, no matter where it's taken place, does not take the case up into a medical malpractice arena. And that goes back with the shower example and then the transportation example.
Just to dovetail that, providing food is also part of what they do. And it's also a dietary issue. If they feed her something laced with cyanide by accident, is that a medical malpractice claim?
No.
Even though they're required to provide her a certain diet?
No.
And I'm just asking, I mean...
The feeding mechanism is custodial. Say if the resident needs help feeding, and you've got a CNA helping to feed, and then person chokes.
Okay, that's a better example probably than mine.
Yeah, then the person chokes. Again, the mechanism of injury is the custodial of helping that person eat, because if they didn't have the dexterity to eat.
So walking like eating isn't providing medical service.
That's exactly.
It's providing a custodial service.
Exactly.
Using a toilet, same thing?
Same thing. And that's why you see all of the cases regarding falls in nursing homes differentiating of what is custodial. And that's why this is clearly custodial, not a medical malpractice case. But next point, obviously, clearly, Escarino is on all 4 points that her son did not have the authority to bind his mom to an arbitration agreement. And also, I do think waiver is a big issue in this case, because Judge Heggie gave the defense the opportunity, when he denied their motion to compel arbitration, 6 months. If you come up with new information in the 6-month time frame, you can bring it before the court. 6 months came and went. It wasn't until 14 months later, now the defense is saying, oh, Michael the son had authority. They had the information beforehand. They put a time limit on it. They waited to the end of discovery, and I had a trial date before they moved for reconsideration. After everything's been done, and I was waiting for my trial date, summary judgments had been filed. So the bottom line, there's multiple reasons that Judge Heggie didn't have to even reach, because, first of all, this was not medical services under their definition. Second, he even gave his opinion that clearly the son is on Escarino did not have authority. Those are 2 main reasons to uphold the trial court's ruling. And then, just briefly to sum up, in the last 2, in this case, only the medical malpractice claims can be compelled to arbitration. Who brings the medical malpractice claim? Only the plaintiff. This is not like my gullet situation where any and all claims go to arbitration. They wrote it to make sure it's one-sided, and it's only plaintiffs who bring medical malpractice claims, not defendants. So there's multiple reasons why the trial court should be upheld in this matter. Judge Heggie considered it at length with the oral argument and the reconsideration, and I would ask this panel to uphold his ruling and affirm the denial of the motion to compel arbitration. Any questions before I sit down?
Thank you.
Thank you, y'all.
And counsel, we asked you more questions, so Elizabeth will give you 2 full minutes. How's that?
Thank you, Your Honors. First and foremost, plaintiff's counsel mentioned several times that wheeling Miss Bernardo in the wheelchair was a custodial service. This is not correct. In order for Miss Bernardo to have been in the skilled nursing facility, she would have been certified by a doctor for skilled nursing services, which in her case would include ambulation around the facility via wheelchair, because in Miss Bernardo's case, she could not have moved around the facility on her own. It was a health care and a necessary service, so it would not be a custodial service. In that regard, I would disagree also with plaintiff's counsel on feeding of a resident, which is not an issue in this particular case. But if a resident cannot feed themselves and medically needs somebody to feed them, that also would be a necessary healthcare service.
So them cooking in the kitchen because the resident can't cook their own meals is a necessary medical service. So cooking meals.
No, Your Honor, because
Why
it
not?
wouldn't be something that you were providing. You're not providing hands-on activities of daily living, ADL care, to the resident, because that's what a doctor would certify and did certify in this case, given the fact that Miss Bernardo was in a skilled nursing facility.
The provision of any activity of daily living is a medical service.
Your Honor, I would say yes.
Does your
Showering.
agreement say that provision of any activity, because that's a clear way to say it. Does your agreement say the provision of any activity of daily living is a medical service?
No, Your Honor, it does not, but we would equate medical services with activities of daily living.
But your client had the chance to put that in. You didn't.
That is correct, Your Honor. The agreement does also talk about any things that are deemed necessary and proper for the health and safety of the resident. That's the specific language of the agreement. I do see my time is up. We'll rest the rest of the issues on our briefing. Thank you.
Thank you, counsel. We appreciate your argument today, and we'll take this matter under advisement and issue a decision in due course. What we're going to do next is we're going to stand in recess, but we're going to remain on the bench for the next case to come forward. Thank you very much.